This film is a project of the Leonore Annenberg Institute for Civics of the Annenberg Public Policy Center of the University of Pennsylvania, in partnership with the Annenberg Foundation Trust at Sunnylands. Citizenship is every person's highest calling. The Supremacy Clause is a funny name for a very basic concept in our Constitution.
The Supremacy Clause was very important to the project of building a nation out of what had been very separate states.
It's called the Supremacy Clause because it tells you what the supreme authority in our legal system is.
Right here in Article 6, it says, "This Constitution and the laws of the United States shall be the supreme law of the land."
The Supremacy Clause essentially put everyone on notice, and everyone agreed because they ratified the Constitution, that we would be one country.
Above everything, the supreme law of the land is the U.S. Constitution, and that's what binds everyone as Americans.
Simple, right? America is one country with one constitution. Well, remember, we're the United States of America. States have their own laws, their own governments and elections. They were here first.
Most of our law, most of the law that affects people's everyday lives is actually state law.
Criminal laws, civil laws, laws about property and contracts, these are mostly state laws. The federal government is limited to the powers listed in the Constitution. A lot of power that's not in the Constitution is left to the states. So wait a minute, who's in charge?
One of the great struggles that American government has always had is to try and figure out what's the right relationship between the states and the federal government.
How do you build one nation out of so many state and local governments? Okay, we're going to talk about national banks and taxes, but this film is about the balance of power between the states and the federal Constitution, and there are 3 lessons to take away from it. The nation almost failed when it didn't have a strong federal constitution to balance the power of the states. The Supremacy Clause gives the Constitution the last word in conflicts between the federal government and the states, and that structure of power has been in place since the Supreme Court's decision in McCulloch v. Maryland. It's the states versus the federal government and the survival of the nation, and all of that is right there in the Supremacy Clause. With me? Let's start with survival. December 1777, Valley Forge, Pennsylvania. You've seen the paintings. George Washington and 12,000 soldiers of the Continental Army were camped here for a brutal winter. The British Army was 18 miles away in Philadelphia, warm and well supplied. But at Valley Forge, only 1 out of 3 American soldiers had shoes. They were sick and starving, and General Washington and his aide, Alexander Hamilton, were begging Congress to get them food, clothes, and supplies. But Congress couldn't get it done.
It couldn't raise money through taxes. It couldn't raise an army. All the things we think of a federal government doing on behalf of a country.
In 1776, the Continental Congress declared independence, and they wrote the Declaration of Independence. And they also wrote another document. It was a document that was designed to be a first constitution, and it was called the Articles of Confederation.
Constitutions are drawn from experience. The 13 colonies were under the thumb of a king and didn't want to create a similar government with a strong central power. So the Articles of Confederation left most of the power with the 13 states.
You had troops in each state, and there was a time in which South Carolina was asked to move their troops to a different part of the war where the battle was waging, and South Carolina said, no thanks, we'll keep them right at home. And so you have that kind of behavior.
The Articles of Confederation did not give you a unified financial system. You could have different currencies for different states.
It was pretty weak as federal governments go, and that was on purpose.
There was no president, no judiciary. All the power was with the states. It was so weak, they didn't really want to call it a national government. They actually called it
a firm league of friendship.
Wait, what?
Yeah, so the Articles of Confederation used this wonderful phrase that they were a firm league of friendship. In fact, some people said that mostly what Congress did in those days was they all showed up and then they went around looking for young women to marry. And but for that, you wouldn't know that even Congress existed. That's actually true.
And because all the power was with the states, Congress couldn't tax them to raise enough money to support the troops when they needed it most at Valley Forge. 2,500 men died that winter without a shot being fired. And when the war was won, Washington, Hamilton, and the leaders who watched their men die at Valley Forge were determined to give the national government enough power for the new nation to take care of itself.
And the consequence is each state going its own way results in a nation that is insecure militarily, insecure financially.
Chief among the people who really disliked the Articles of Confederation was General George Washington. No one could raise enough money to pay his troops. So Washington wanted to have a stronger national government, and he found other men who agreed with him.
Alexander Hamilton was one of the very strong voices.
James Madison thought that the states were an enormous problem.
So they met in secret in Philadelphia to write a new constitution with a strong federal government. One with 3 separate branches and all the powers necessary to build a new nation. The power to raise an army, to levy taxes, to regulate the national economy, and to pass laws that would apply to every person throughout the country.
What they come up with, of course, is a whole new system of government. They come up with the Constitution.
And while states kept a lot of power under this Constitution, they gave federal law the last word right here in Article 6 with the Supremacy Clause.
The Supremacy Clause creates a first and primary loyalty to the Constitution.
It says that the national government is the supreme government. The Constitution is the supreme law of the land.
But some of the framers were pretty upset about this. States like Virginia had been around 170 years before the Revolution, and they didn't want this new government far away from their state telling them what to do.
Historically, we use the term Federalists and Anti-Federalists to describe 2 different general views about the Constitution. The Federalists are the people who defend the Constitution.
The intellectual leader of the Federalists was Alexander Hamilton. Hamilton was an immigrant from the Caribbean who joined the New York militia and quickly rose through the ranks to become a chief aide to General Washington. After the war, he helped found the Bank of New York and became one of 3 delegates sent by New York to the Constitutional Convention in Philadelphia, where he argued for one thing.
He wanted a very strong and powerful national government.
Hamilton's rival was Thomas Jefferson. Jefferson was the primary author of the Declaration of Independence. He wasn't at Valley Forge with Washington and Hamilton. In fact, Jefferson spent part of the war as governor of the state of Virginia. He wanted the states to remain strong.
The Anti-Federalists argued that the states had lost all their power, and the whole thing was going to be a complete disaster.
Jefferson didn't go that far, but he wanted a Bill of Rights to limit the power of this new government. James Madison, now siding with Jefferson, wrote the first 10 amendments to the Constitution.
And what the 10th Amendment says is that those powers not delegated to the United States are reserved to the people and the states.
We have authorized powers to the federal government, but everything else that's not covered in the Constitution is reserved to the states.
The problem was you were never quite sure where that line was.
So now we've got a constitution, a Congress, a judiciary, and a president. George Washington was elected in 1789, and he put both rivals in his cabinet. Thomas Jefferson became Secretary of State, and Alexander Hamilton was the first Secretary of the Treasury.
And they clashed almost immediately. It was mainly philosophical, but they also didn't really like each other too much either.
Alexander Hamilton believed that the convention had given the national government significant powers.
Hamilton argues that we need a bank. A bank is necessary to collect taxes. It's necessary to coin money. It's necessary to pay off debts.
The Anti-Federalists hated this idea. Each state already had a bank. They worried that a national bank would take money and wealth from the states and give it to the federal government.
Jefferson looks at what Hamilton wants to do, and he's scared by the concentration of capital in the nation as opposed to in the states. He thinks that the states should be the center of power in this new government, and that the states are the way that we will prevent tyranny from happening again.
But Washington and Hamilton remembered Valley Forge. They remembered how a weak federal government almost lost them the war, and destroyed the young nation.
And Washington ends up siding with Hamilton.
In 1791, President George Washington signed the bill establishing the first bank of the United States. But they make a deal. In exchange for a national bank, the nation's capital moves south, closer to Jefferson and Madison's home state of Virginia. And the Anti-Federalists got one more concession. The bank was chartered for only 20 years. So in 1811, President James Madison let the bank expire.
Right before the War of 1812.
And in fact, what happens is the War of 1812 under President Madison takes place, and they have similar kinds of problems that had existed under the Articles of Confederation. The absence of the bank makes it hard to raise money, and after the war ends, Madison realizes, wow, we really do need a bank. It really did serve a purpose. Boy, wouldn't it have been convenient to have had a bank while we were fighting the British in the War of 1812, and they charter a new bank in 1816.
So, lesson learned again, right? No.
Not everyone is happy about this bank, and a lot of the states are very agitated about the bank. They think states should have banks, but they don't think the federal government should have a bank. It's too much power, it's too much consolidation, and what happens after the bank is chartered is states start to attack it. And one of the main ways that they attack it is they tax it.
They wanted people to bank with them, not with the second national bank. And some of the states thought, well, we'll try and make money off this bank.
Tennessee, Georgia, North Carolina, Kentucky, and Ohio all imposed taxes on branches of the Second Bank of the United States operating within their states. The state of Maryland introduced a tax of $15,000 a year on all banks not chartered by that state. And in 1818, there was only one bank that fit the bill.
The tax is structured to specifically apply and only apply to the Bank of the United States.
The Maryland branch of the federal government's Second Bank of the United States was located in Baltimore. It was run by James McCulloch. We can't find an image of him, but we did find an old educational film about the case, and they thought he looked like this.
That is correct.
James McCulloch would have been the man to pay Maryland's tax on the Second National Bank.
Right again.
But he refused to pay Maryland's tax, and in this old school film, when Maryland threatens to sue, what McCulloch says is old school for bring it on.
We have no intention of paying the state tax. Not now, not at any time in the future. If under the circumstances you want to take us to court, please do.
James McCulloch understood two things. One, the federal government could not let the states tax it.
If you can tax an entity of the federal government, you have the tool to destroy that institution. You can just tax it out of existence.
And two, the Supremacy Clause probably wouldn't let that happen.
There's a concern that you have an entity that is less supreme under the Supremacy Clause, a state exercising some measure of control over an entity that is more supreme, the federal government.
On February 22, 1819, the Supreme Court heard oral arguments in McCulloch versus Maryland.
McCulloch was a huge case at the time, and it was a really big controversy. Everybody understood that the stakes were not only about the bank, the stakes were also about the larger separation of power between the federal government and the states.
McCulloch's argued by 6 lawyers. There was a rule that you were only supposed to have 2 lawyers per side, but the court knew this was going to be an important case, and so they said everyone could have 3 lawyers.
At the head of the Maryland team of lawyers was Maryland Attorney General Luther Martin. Martin had been a delegate to the Constitutional Convention in Philadelphia back in 1787 and had refused to sign the Constitution because he felt that it violated the states' rights guaranteed under the Articles of Confederation.
He had opposed the strong national government that was being created in 1787. Luther Martin also drove people at the convention crazy because he talked forever.
On the side of the federal government was one of the greatest orators in American history, Daniel Webster. Webster's reputation was so good that Hollywood made a movie showing him winning a case against the devil.
Gentlemen of the jury, don't let this country go to the devil!
Webster had a fabulous speaking style. He was so exciting to listen to. People wrote reports about how, after he spoke, they could barely go over and touch him. They felt like he burned like the fire.
And presiding over the Supreme Court was a man who arguably had more influence over the United States judiciary than any other person in history, Chief Justice John Marshall.
John Marshall is probably the greatest Chief Justice the Supreme Court has ever had. He's enormously influential.
The reason he's so important is because he gives the Supreme Court the stature that we know of it today. He is the first person to say the Supreme Court is a really important institution.
John Marshall wrote the decision in Marbury versus Madison, establishing the principle of judicial review, the idea that the Supreme Court can overturn the actions of the legislative and executive branches if they violate the Constitution. Before Marshall, it wasn't clear who had final say over what the Constitution said.
Suddenly, the Supreme Court of the United States has very, very considerable power, even over the Congress of the United States. You could say Hamilton and Madison were the architects of the Constitution, but he was the prime interpreter of the Constitution, and we still owe a great deal of thanks to him for that.
John Marshall served as Secretary of State under President John Adams. And there's one more thing you should know about Chief Justice Marshall.
John Marshall had been at Valley Forge with George Washington.
It was the insistence on state rights that drove us to the brink of disaster. We would have perished. I know it.
John Marshall had been one of the people who argued strongly for the fact that we needed a strong national government.
Over 9 days of arguments, the foremost lawyers in the country and the greatest jurists in our history came together in the Supreme Court. And before a packed house with newspapers delivering blow-by-blow accounts, they battled it out over who was ultimately in charge of the nation, the states or the federal government.
Maryland's main argument in the case is that the Constitution does not authorize Congress to charter a bank. You don't need a bank to collect taxes. Maybe it's easier, but you don't need it.
Absolutely goes back to Jefferson's argument. There's nothing in the Constitution that would justify creating a national bank.
Luther Martin complained endlessly in a very long argument that the national government shouldn't have all the power, that the states should be given more power. And this was the same argument he had made many years ago in Philadelphia.
Daniel Webster argues that federal law is supreme.
Webster's argument basically ends up mimicking the arguments that Alexander Hamilton uses in defending the bank way back in 1791.
The lawyers for the bank also argued that no state could tax a part of the U.S. government or something authorized by the U.S. government. They argued that if you could tax something, you could destroy it.
On Saturday, March 6, 1819, Chief Justice John Marshall delivered his opinion. In a unanimous decision, the court ruled that the federal government had the power to create a federal bank and that the states had no power to tax it because federal law, through the Supremacy Clause, is supreme. This great principle, Marshall wrote, is that the Constitution and the laws made in pursuance thereof are supreme, that they control the Constitution and laws of the respective states and cannot be controlled by them.
John Marshall took the position the national government has to take precedence. It has to be able to do what is necessary for it to continue in existence. It has to do what is necessary for it to execute policies that it's allowed to have.
Marshall argued that Congress had the power to create a bank because the Constitution gave it broad powers to protect and stabilize the nation. Even though that power isn't enumerated, the 10th Amendment doesn't just give it to the states.
Marshall's most famous line in McCulloch is where he says, "We must never forget it is a constitution we are expounding." That's very fancy for saying we interpret a constitution differently. And Marshall thought you interpreted a national constitution differently from the Articles of Confederation. In some ways, McCulloch is an argument that Marshall's having with people who objected to the Constitution in the very beginning.
What McCulloch did was it basically made the federal government much stronger vis-a-vis the states than it had been before.
McCulloch is viewed today as one of the really fundamental early decisions that sets out what kind of a constitution and what kind of a government we have.
Today, what has endured from McCulloch is not the bank that Alexander Hamilton, Daniel Webster, and John Marshall fought to preserve. When the Charter for the Bank of the United States came up under renewal again in 1832, President Andrew Jackson, a strong supporter of states' rights, vetoed it. 80 years later, the Federal Reserve was created after a series of crippling financial crises, but seriously, that's an entirely different film.
The legacy that McCulloch leaves is not the existence of a national bank. We don't have a national bank today. The legacy is really about the structure of power as between the federal government and the states.
And in the centuries since McCulloch was decided, the Supremacy Clause has remained central to keeping us together as a nation.
In 1860 and 1861, when states are seceding from the Union. And one of the questions that the president, Abraham Lincoln, has to answer is, does the Constitution give individual states the power to secede? The Supremacy Clause is an important part of the argument for saying, well, no.
In the 20th century, many states weren't willing to uphold important civil rights cases like Brown v. Board of Education.
That decision really has echoes of McCulloch versus Maryland. Can the states defy an act of the Supreme Court? And the ultimate answer is no.
Today, we don't argue about whether the Constitution is ultimately supreme over state law, so much as where federal power ends and state power begins. In cases ranging from environmental law to immigration enforcement, vehicle safety standards to voting laws, conflicts between state and federal law happen all the time. And Chief Justice Marshall predicted as much in his McCulloch decision, saying the debate over state and federal power will be perpetually arising and will probably continue to arise as long as our system shall exist.
Our Constitution sets up a lot of structures, and it stacks them up in this great edifice of American democracy. You know, there are the local governments, there are the state governments, there's the federal government on top of that. But what prevents the whole tower from falling down? The Supremacy Clause is really the glue of our constitutional architecture.
What's really great about the Constitution in some ways is it begins with that strong, we the people. And then it goes along explaining everything. And then right near the end, it has this little reminder that actually the Constitution and the laws of the government are the supreme law of the land. It's almost like if you read a long book and were wondering in the end, what did all this matter? The Supremacy Clause reminds us, actually, the whole point of this Constitution is we agree to be one nation.